path to winning isn't easy. Do ERISA regulations require that a reviewing liar-for-hire physician match your treating doctor's specialty in rendering an opinion about your case? Now, disability carriers will always use reviewing physicians during a claim assessment. These doctors are going to evaluate things like, is this diagnosis accurate? Are your symptoms aligning with the test results? Do your restrictions and limitations match the objective findings on examination and diagnostic studies? Is your treatment and medication appropriate? Is the frequency and nature of that treatment correlate with the level of the complaints that you have about your pain or dysfunction? How functional are you really? Those are the kinds of questions that I see commonly asked of the adjuster of the peer review doctors. Now, the question becomes, does the doctor that is doing the peer review have to match your doctor's specialty? And the short answer is no, as dumb as that may sound. Under the ERISA statute and regulations, the reviewing physician doesn't have to match your doctor's exact specialty. They only need the appropriate training and experience in the relevant area of medicine. And quite frankly, I think that's bull. And I'm going to explain and give you an example of why I think that's bull. This is the case of Black versus Unum Life, and it's a case out of Texas. And Ms. Black had thoracic outlet syndrome. She had injections, surgery, and she continued to report pain, particularly using her right arm. Of course, Unum had her case reviewed by a vascular specialist and not a thoracic outlet specialist like her treating provider. And I will tell you, I have represented people who have thoracic outlet syndrome, and I don't think vascular surgeons are competent or qualified to render opinions. In fact, they will often refer their patients to a thoracic outlet specialist. And those doctors can be really hard to find because they are super specialists. Now, Ms. Black challenged the denial partially on that basis. And ridiculously, in my opinion, the court upheld that denial. And according to them, a vascular surgeon was close enough. Now, I think that's dangerous. In a complex case like fibromyalgia, long COVID, CFS, or POTS, and even thoracic outlet syndrome, I don't think close enough is good enough. Unfortunately, ERISA allows for this gray area. So you might see a fibromyalgia claim being reviewed by a family doctor while your diagnosis came from a rheumatologist with years of specialized experience. That's why I think that challenging and providing rebuttal evidence from physicians of equal or greater expertise is so important, particularly if they are an expert. I think that this decision, this Black decision, is a bit of an outlier. As I read the case law, as I do weekly, I think courts are very sympathetic to this argument, particularly if you have a super complex medical condition and the peer review doctor doesn't have any training, expertise, or any specialty in this particular area. So this is something that we hammer, knowing, of course, that there are cases like Black versus Unum that's out there. So let's wrap this up. When you apply for disability insurance coverage, you need to be truthful and you need to be thorough because any omission can cost you your policy and your benefits. Also, when you are applying for your disability insurance benefits, which is different than applying for coverage, you need to make sure that there isn't this pre-existing condition clause that would impact your ability to get benefits. It's called the look back period or the pre-existing condition clause. That's going to impact the timing of your stopping work and filing the claim. It might be that you shouldn't get medical treatment for a certain period of time or take medication that's been prescribed to try to get around that pre-existing condition clause. You should only be doing that, I think, in consultation with an experienced ERISA disability attorney. Now, if you've been set for an independent medical evaluation, you should not trust that the word independent means independent. That's a bell that should go off, and you should be contacting an experienced ERISA disability attorney and hiring them to represent you. If your claim has been denied, you need to understand the medical reasons why that claim has been denied and go about creating rebuttal. Rebuttal that points out what's not only wrong with the opinion, but that how that opinion might be a violation of ERISA rules and regulations. And understand, of course, that insurance companies don't have to match your doctor's specialty for the most part. So you need to challenge their experts wisely. And again, that should be done with the assistance of an experienced ERISA disability attorney. These are the kinds of issues that I see in my practice every day, and they trip up countless claimants every year. But now that you are informed and empowered and ready to stand your ground, you have a better understanding than most people who walk into my office wondering what on earth happened, why their claim got denied, and what can be done to get the disability benefits they deserve. So thank you for tuning in to this week's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, share it with your family or friends, and subscribe to this podcast. Join us next week for another insightful episode of Winning Isn't Easy. Thanks for listening.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.